In the aftermath of the hearings into the crash of Flight 427, there are still so very many questions, and as we saw last week, so much pain on the part of the families. Good afternoon, I'm Ann Devlin, and today you meet John Gismondi. He is an attorney representing some of the families and the lead counsel representing a group of the plaintiffs against U.S. Air. Well, we heard what the officials had to say last week, and it seemed that all the questions were answered with simply more questions. And another opportunity that we had last week is really to hear from the families, to hear what has gone right, little, and gone wrong, seems a lot, as they have tried to get not just answers, but even things as simple as their loved ones' belongings. Those series of revelations, perhaps, were more enlightening than anything that came out of the official testimony, and still we don't know why Flight 427 crashed. John, what, in your view, what was accomplished last week?
Well, I think as far as the crash itself is concerned, and I think if nothing else, they did narrow the focus. They eliminated the idea that perhaps there was a bomb on board. I think they kind of minimized the idea that wake vortex or turbulence from a plane ahead of 427 played a major role, and I think they focused in on the rudder, and they determined, I think as of the end of the week, that a left deflection or movement of the rudder was really the key event that started the plane into a bank, which turned into a roll, which turned into the crash. And now we're left with the question, well, why did the rudder deflect or move to the left? Did the pilot do something wrong? Or did the rudder unit itself malfunction? I think that's where we're left after the hearing. More questions to be answered.
Does my memory serve me correctly? Was the plane on automatic pilot when this event happened?
It is on what's known, it was on autopilot when these events started in the last 25 seconds or so. That's correct. The autopilot, I think, was off 7 or 8 seconds into the event.
Do you have a suspicion?
I have a suspicion that something went wrong with the rudder.
Not that the pilot precipitated this
Well,
event.
I don't know that. When I say something went wrong with the rudder, it was either moved purposefully or was moved when it wasn't supposed to be moved by the rudder system itself.
John, here I am, a layperson, watching these hearings with more interest than I've ever watched any of these other NTSB hearings. What struck me was how distressing it might be for family members to believe or suspect that some of the experts who were testifying last week were more about the business of posturing than they were true and honest pursuit of the facts. That some of the company representatives were more interested in saying, well, maybe it could have been a bomb. Don't rule that out. Maybe these federal agencies didn't do their job. The investigation wasn't thorough enough. Maybe there are still questions out there. I found that, as a layperson, frankly shocking. What was your reaction to it, and do you believe there was genuine testimony delivered last week? And what percentage of what we saw was nothing more than posturing or kind of like official technical public relations for the companies involved?
Well, I think there was an element of that. I would characterize the testimony as cautious. I would also characterize the questioning that the witnesses were subjected to as a little soft, certainly not as intense a questioning as you would expect in the courtroom. Hold
on, can I ask, how could that be? Is that standard procedure for these hearings? And that raises the question, are they a waste of time? Well, is the true answer only going to be found when everyone really knuckles down and we're in a court of law?
Well, I think you get better answers in a court of law because we're set up to provide better answers. The thing you have to remember, Ann,
but everyone's under oath, right? They were under oath for that hearing last week? Sure. As they would be under oath in a court of law. So what the heck is the difference?
Well, one of the big differences is that most of the people you saw testifying last week at the hearings, as you say, were company people testifying about their own conduct. You had U.S. Air testifying about, their own conduct. You had Boeing testifying about their own conduct. You didn't have kind of independent people looking so much at their conduct.
What is the NTSB?
Well, the NTSB, to a large extent, is relying on, for example, Boeing to go out and perform certain tests and come into the hearing and report. If you remember, Ann, one of the things, when they began to focus on the rudder was the question of, gee, did the rudder malfunction? Well, company representatives from the company that manufactured the rudder system in Boeing indicated, gee, we ran tests, and when we ran tests on our own product, it worked fine. Well, I don't know whether or not somebody not associated with the company would come to the same conclusion. And that's a little different flavor that you get in a courtroom setting. And you get a little different style of questioning in a courtroom setting than you do in a hearing.
And this is really, I think, troubling to taxpayers who footed the bill for a week's worth of hearings. Suggestion being that unless there is an adversarial circumstance, what is delivered in a courtroom, the independence of the NTSB does not necessarily deliver the truth.
Well, I don't know that the NTSB, frankly, has the time and money to go out and do what might be done in litigation. To a large extent, they have to rely upon the aviation industry to provide information to themselves and information to the NTSB.
But you know what's so interesting to me? Here's another layperson's observation. When it's wind shear, a natural event that perhaps no one could foresee, and again, before we've had, in the last couple of years, we've had the introduction of some sophisticated aviation equipment that helps pilots detect wind shear. It seems like those kinds of conclusions are arrived at very quickly. Everyone nods their head, boom. Everyone accepts that Mother Nature can do freakish and horrifyingly tragic things sometimes, and we're against the forces of nature. When it seems to be a mechanical problem, or the suspicion of a mechanical problem, then there are never any conclusive, definitive answers.
Well, I don't know.
Is that a correct observation on my part?
I don't know if you can say that as a general ruling, and I think you can say it in this case. I don't think there's any question that this has been probably one of the most difficult cases the NTSB has ever faced in terms of trying to sort everything out.
Why? What makes this one so different?
I think a couple of things. Number one of the major complaints that you heard from the NTSB and the FAA was that this plane did not have the more sophisticated monitoring equipment on it that would have given them more information.
And isn't that something?
Yeah.
What Boeing was selling planes, similar models, to Great Britain with that advanced equipment, but the domestic carriers didn't have that advantage.
They're in the process of retrofitting, but this plane did not have the more sophisticated monitor. So I think that's one reason. I think the other reason is, the unbelievable level of destruction here. The NTSB often goes in and they're able to recreate certain things based on what the wreckage appears like. The wreckage was completely, the level of destruction here was almost unprecedented. I think that's a second thing that contributed to it. A third thing, they had very little clues in the cockpit voice recorders. There wasn't really anything that the pilots said that gave them a great clue. So those are some differences maybe between this accident and some others that they've had a little easier time in solving.
All right, so you represent some of the families. You are not at liberty to disclose how many. You are lead counsel for a group of the plaintiffs.
I'm among the lead counsel,
Among the
correct.
lead counsel for the group of the plaintiffs. What did you learn last week?
Well, as I said before, I think we learned that the rudder is the proper place to put the focus at this point, and it's a matter of trying to determine what went wrong with the rudder and why it went wrong.
All right, but what did you learn as an attorney representing those families as you develop a strategy to perhaps ultimately, are you inclined to settle at this point, or are you inclined to take this into court?
Well, I think it's too early to say that. I mean, you have to remember from a litigation standpoint, the litigation really is barely underway. Maybe 2 months, which is really the infant stage as far as litigation is concerned. So at this stage, it's really too early to say.
In most of these cases of crashes, and similar circumstances, for example, the Colorado Springs crash, where in fact there never was a conclusive answer.
Correct.
The majority of the cases settled out of court?
There are still some of those cases, as I understand. I'm not involved in that accident. As I understand it, there are still some of those cases that the litigation is still going on. There are some that have been settled, but it's still going on. And you're right, that was one of only 4 cases, I believe, in the history of the NTSB that no cause, or probable cause, as they call it, was ever issued.
So if you had to project here on crystal ball, would you expect the majority of the families will settle out of court? We already have the first settlement this week with a Monroeville widow.
I really think it's too early to say. It's just too early now to say. I think things need to be sorted out a little more before I could accurately predict for you how each of the individual cases might go.
It raises the question, though, if you're saying truth really only comes out in a court of law, if the majority or all of the plaintiffs settle out of court, what happens to the pursuit of the truth?
Well, I think that the courtroom is the best environment to get to the bottom of something. You know, whether or not certain people may settle claims doesn't prohibit, you know, the claims that still exist from going on and, you know, in having a full-blown trial. But again, whether that's going to happen or not, it's simply too early to say.
I'll come back to that in a moment. How did you get involved with this case?
Gee whiz, how did I get involved? As with anything else, you get a call from somebody, they ask you to represent them, you get a call from somebody else. No different really than any other case, to be honest with you.
Do you have specific experience in aviation law?
Yes, as do others involved in the case, both locally and nationally. A lot of good attorneys involved in this case.
So what do you do in these infant stages of the development of litigation?
I think one of the earliest things we're involved with now, Ann, is trying to collect documents and information. We're in the process right now, as a matter of fact, of getting documents and information pertaining to the crash that you mentioned a moment ago, the Colorado Springs, which seems to be the one most similar to Flight 427. We're in the process now of gathering information from that. As we go on in this investigation, in addition to gathering documents, you subpoena or have witnesses sit down for questioning under oath in what are known as depositions, and you have the information analyzed. You know, one of the things that many people don't realize is that if the NTSB does come to a conclusion here and issues a probable cause determination, that isn't binding on anybody. That's not admissible in court. When you go into litigation, both sides have the responsibility of having their own witnesses analyze all the information and come to their own conclusions and persuade the jury that they're correct.
Stand by with me for just a moment. We'll come back and continue conversation with John Gismondi, who was representing a number of the families involved in the crash of Flight 427, the aftermath, the investigation. He's also one of the lead counsel for a group of the plaintiffs. We'll return in just a moment. John Gismondi is our guest. He is one of the lead counsel representing a group of plaintiffs who may or may, well, may be following legal action, are following legal action against, what, U.S. Air and Boeing?
Correct.
In light of the crash of Flight 427. These are survivors that you're representing. I want to get to some of the family issues in just a moment here, but a few more legal beagle questions,
sure,
if you will. You say that I'm still not sure I understand, by percentage, how many people, next of kin survivors of crash victims, settle out of court?
I think it's really hard to say, Ann, you know, in predicting in any one case what will happen. And there's also the question of, you know, over what period of time. You know, it's very, very difficult to say. You know, cases are capable of being settled at any point from day one up until literally the courthouse steps.
How do you counsel people on whether or not to settle out of court versus pursue the legal action to the limit?
You have to look at their individual circumstance, and I'm sure I'm no different than any of the other good attorneys that are involved in representing these families. Every family is different. You look at the individual circumstance, and in the end, the family controls. The lawyer gives advice. The lawyer answers questions. But in the end, that is always the family's decision. The lawyer gives advice, but the family controls. And every family has to be treated individually. So you can't predict across the board. What's good for one family may not necessarily be so for another.
You said the development of litigation or possible litigation now in its infancy. What's the timeline?
That's a good question, Ann. I think to understand this, the timeline, I should point this out. If the case is going to go actually to trial on the question of why did the plane go down, that is a case that would be tried one time, not 132 times. It would be tried one time, and it would be tried in Pittsburgh. After a trial on that question of why the plane went down, there would then be individual trials if families desired them on their own individual claims. For all of that to be over, it depends really, I think, on that first step. How long does it take to get to the issue of why the plane went down? If that's going to go to a full-blown trial, you know, it's certainly, you're looking at a trial not in 1995, not this year, but it's very difficult to predict so early on in litigation how much longer it's going to go on.
How often is that cause found actually in a courtroom?
Well, I think in most instances, a jury, I mean, the jury does come to a conclusion.
No, I'm saying how often do these kinds of cases end up in court to find a cause?
Oh, a fair number. A fair number don't get that far. Again, I think each individual case is different, depending on the strength of the proof.
If tomorrow, what could end that from happening? It would be an NTSB finding about a cause?
No, because remember, an NTSB finding is not binding. It's not binding in private litigation.
Would it be, for example, you say, gee, the rudder seems suspicious after the NTSB hearings. Would it be Boeing coming out and saying, we believe it's the rudder? Or we have found performance problems with the rudder?
Yeah, I think the best way to answer your question, Ann, is this. Your question is, well, what would end this litigation prematurely? The answer would be no different than any other litigation. That is that both sides get together and somebody comes forward and says, okay, we do not want to go in and contest or try the issue of why the plane went down. And we will agree that it went down and so is responsible. So people can voluntarily, companies or whatever, can voluntarily agree to avoid going forward with a trial.
Does that achieve the truth?
Well, that's a good question. If there is no trial and if there has been no NTSB finding, do you ever know for certain? I think that depends on the strength of the proof that you've developed during the investigation stage, which, as I said, is very, very early on right now.
What I'm getting to, obviously, is would future passengers then have assurance that lesson was learned from 427, changes were made?
Well, I think this, Ann, I think that the NTSB, certainly that's their focus. That's their primary focus, you know, preventing future accidents. So to the extent, you know, they wrap up their investigation and they come to a conclusion, assuming they do, they're certainly going to do what they regard as necessary or pass on to the FAA what they regard as necessary to prevent future accidents. So, you know, that focus is there from the NTSB, from the FAA, and once they determine a conclusion, assuming they do, while it's not binding in private court cases, it certainly is a springboard for them to take whatever corrective action, you know, they think needs to be taken. Again, assuming they come to a probable cause determination here.
How much more do you know than we know? For example, have you heard that last 25 seconds in that cockpit before the plane crashed?
No, we have not heard. That has not been made public. The actual oral part of the tape, I mean, the transcript has been released, but it
was edited, correct?
To some extent.
Yeah.
But the audio itself has not been released, so no, I don't...
Are you in pursuit of that?
Yes. Yes.
And do they have an obligation to share it with you? How does that work?
Well, actually, it's the FAA that now, you know, that has the tape, so we have to get it through what is known as a Freedom of Information request. And I think, if you remember from the hearings, there were some sounds certainly in the background of the tape that would be, you know, of interest to analyze. Not simply the words that are on the tape, but there are sounds on there that, you know, that may provide some clues. So we think it's important to get the tape, get a listen to it, and have it analyzed.
Do you believe that the NTSB shows any measure of favoritism toward the major airline carriers or airline manufacturers?
Well, I don't want to say any measure of favoritism, but as I alluded to before, you know, their setup is such that historically there is, you know, a rather close relationship between the NTSB, the FAA, the aviation industry. As I said, they don't have a lot of the resources necessary to go out and do a lot of things on their own, and to a large extent they have to rely upon the aviation industry to provide information to them. But I certainly had, you know, certainly the people that were in Pittsburgh last week, I think under the circumstances for the NTSB were trying to do the best they could.
Let us shift focus here to the families. One of the more enlightening things that came out last week was the revelations from the family about what they felt their grievances were with U.S. Air in the aftermath of this crash, getting down to getting their loved ones' belongings back.
It was a tough time, very, very tough time. I think, as you indicate, there were a whole litany of tension areas between the families and U.S. Air. And I think it's, you know, it's understandable. People have been through the most unimaginable tragic circumstances where their lives have been turned upside down literally in minutes.
See, that all I expect. And I expect that no matter what a company is going to do to try to make it right, they're never going to be able to deliver Dad or a husband back to a doorway and make that family whole again. So there are naturally going to be rubs. But not returning loved ones' belongings, wedding rings, car keys. Again, as a layperson, that shocked me.
Well, I think there certainly was some distress, you know, on the part of the family members about the circumstances under which they would be given access to those personal effects, maybe some delay involved, and you're correct. I mean, you know, there was definitely some distress over how things like that were handled, how they were given access to personal effects and things of that sort. You know, and it's something that I think is a learning experience from U.S. Air's standpoint. You know, hopefully.
You wouldn't think it would be that way. We're going to pause right here and come back in just a moment to wrap up with John Gismondi. Wrapping up with John Gismondi, an attorney representing a group of the plaintiffs involved in litigation against U.S. Air and perhaps others in the aftermath of Flight 427's crash. Very quickly, a final thought here. We saw the family tension surface last week at the NTSB hearings and outside. Do you advocate a family advocate in circumstances where there might be another crash?
I don't think it's a bad idea. It would be up to the FAA or the NTSB to set up such a program. I don't think it's a bad idea to have a go-between, you know, to ease the tensions between the airline carriers and the families.
You tried to be that. You tried to negotiate last week.
We did on the issue of getting access to the personal effects. Spent a good bit of time doing that. Thought at one point that we had it worked out that the personal effects would be brought down to the hotel for people, but in the end that they would not agree to do that.
Your conclusion out of that episode?
Well, I think that, as I said, I think that the airline carriers have to realize how sensitive a family understandably is in a circumstance like this. And I think they have to appreciate the frame of mind the family member would be in, which is very, very understandable, and try to do whatever you can